The classic one that happens is where there's some kind of fallout or dispute between shareholders in a company. So they've almost been able to demand a ransom and extra special terms for them, even though they only own a small percentage. But if they create an expectation that something will happen, say in 1 month, if that's completely unrealistic, that can then create the disenchantment and dissatisfaction from the other side. Don't wait until you think you're old and that's when it's more likely that that's going to come in handy. You just do it. It's just one of those things.
The following interview is with Rishi Malliwal, who is the partner at SGM Law, a law firm specializing in corporate and commercial law with a team that works closely with owners who look to sell their businesses. Rishi has previously sold his own firm, and so today we discuss the nuances that business owners may not be aware of when selling their businesses, the importance of starting the preparation process well in advance, and of course the legal aspects that are crucial to getting your business in top shape before putting it on the market. I hope that you enjoy the conversation as much as I did. It would be interesting to know how, because obviously you're partner at SGM Law. It's been running for, correct me if I'm wrong, but over 6 years now?
Yep, that's right.
Which is crazy because I looked at it and I thought 2019 seems like a couple of years ago only, but has been 6 years. So just interested to know how that came about. Obviously, it is a business that you run now. So it would be interested to hear how you ended up there.
So I've been a lawyer for about 21, 22 years, specialising in corporate and commercial law for most of that time. After a time spent in some big law firms in the city, it was originally about 11 years ago that I started out my own business through a series of initial firms that I had. We then started SGM in 2019 after I sold a business, actually. So I sold an old firm that I had created, and then the firm I currently run called SGM Law was born. It feels like it was only 2 years ago, and those COVID years were quite unusual, I think, for a lot of people in terms of how time passed. But yeah, it's been 6 years already.
I think it's also interesting the transformation the business goes through because of COVID and like how things just get reorganized. Like, what have you seen from your side? Did things start to run differently post 2020, 2021?
Well, because SGM was a new business, we were able to start things from the ground up in a very sort of tech-friendly way. So from the day dot, we were able to work from home, work remotely. All our systems were designed to be able to operate in that way, and that was really important to us pre-COVID. Obviously, then post-COVID, we didn't really have to make too many changes. We had an office, but we stopped going into the office. We are going back again, but the business, SGM Law, has always been based on a very sort of allowing complete flexibility in terms of working. So all our team can work anywhere in the world. Mm-hmm. They just need a laptop, a mobile phone, and an internet signal. That's it. Mm-hmm. So we didn't notice too many changes in how we operated, but that's because we were set up in that way in the first place.
Do you find now that also clients are probably more open to perhaps just meeting online as opposed to in person as well?
Yeah, that's been a real shift actually. Before COVID, I'd almost always meet our clients face-to-face normally, or at least early on there'd be some kind of face-to-face in-person meeting. And I struggled to believe that it would be possible to get clients on board if you're doing M&A or these kind of projects with them without doing that. But that's what happened because it had to. So we took on, I remember one of the first clients that we took on who I never met. I just had a video call with them. They said, oh, this is what we want to do. I said, okay, we can help with that. We went through the usual onboarding process, did the work, and that was it. And it was a bit of a revelation initially, but now it happens all the time. We have new clients coming to us from overseas or in this country, and we'll often never physically meet them. We'll have video calls, and we'll often do that. The video calls then don't replace an in-person meeting, but it's a lot better than a phone call. So you can certainly get a real sense of what someone is about, both from our side as an advisor, and also I think for clients, if they can look into the whites of your eyes and hear you talking and hear you describe how you can help them or what the solution is for their particular issue. I think that's much more impactful. Yeah,
it is interesting though that obviously, like you said, it was a shift from the client side as well, not just from the business side of things. Because before, a lot of clients would have definitely preferred to meet face to face, and then as society had to adapt, they had to adapt as well. which is interesting to observe. I think one of the things that you did mention about selling the previous firm as well. So was that correct me if I'm wrong with pronunciation, but Sprocher Greer, was that the name of the firm?
Sprecher Greer, yeah, that's right.
Right.
That's right.
Yeah.
Yes.
Was that German or?
No, it was an English law firm. Two English guys, David Sprecher and Ian Greer, originally started a firm with that name.
Okay.
That firm didn't exist anymore, but we then reused that name in a new firm that I created.
And what was it like? Because obviously, anyone who's watching this, there might be business owners who are contemplating exit as well. What was it like going through that process of actually selling the business? And what was it like being on that side of the fence?
I think it was very instrumental in how we are as a business now, and that's for two reasons. One, so I've been a lawyer for over 20 years and had, prior to starting my own business, I was a partner. I was advising clients all over the world on buying, selling businesses, all sorts of transactions. But it was really when I started my own business, I then really realized what it was like to operate a business and how little time you have, how important certain things are and how unimportant certain things are. And it really distilled down to me when I was going through that myself, what actually is important. And it made me change how we advise, what we advise on, what we do completely. And one big example of that is when I sold my firm, I then became even more aware of what actually is important. And some of the stuff that I thought was important as a lawyer up to that point actually turns out was not that important. And so we advise in a very different way, and large part of that is based on that actual experience of going through that process myself. Most lawyers have never used a lawyer.
Okay.
Other than to buy and sell their house, but most lawyers have never used a corporate lawyer. Or they've never sold a business or bought a business. I've done those things. And so that informs how we operate. And I think the clients that work with us really recognize and see that experience, because it means we cut through and focus on the stuff that's actually important. And that's one of the gripes. In fact, I was talking to a client this week, and this is what he was complaining about. We're not advising him on the particular deal he's doing, but he was complaining about the lawyers getting too bogged down in things and dragging things out, and doesn't seem to understand the stuff that is actually important to them. I think that is often because lawyers are dealing with it as a legal process and not having had the benefit of going through it themselves to know what's actually important in that process.
There's something interesting that you mentioned, which is that you said some things are just not as important as you thought they were, and some things are actually very important. So do you have any examples of those?
Yeah, so one main example that I think I really talk about is it's how advice is delivered. So I personally like to talk to people, or I want someone to talk to me and explain it to me. And that sort of communication about, particularly if it's something a bit complicated, if you don't understand it, it's easier to, ask another question and go, oh, do you mean this? No, I don't mean that. I mean this. And make sure that it's understood. To do that verbally is a lot easier. Whereas if you do that in writing, in an email, for example, that could be like a 3-page email. No one wants to go through a 3-page email, or you have to sometimes, but it takes a lot of time, energy, it's quite taxing. Whereas you could replace that with a 5-minute, 6-minute telephone conversation, and that's much more productive. So often I will pick up the phone first or have a call with someone, go through an issue with them, make sure it's understood, bounce it round verbally with them, and then get their opinion on it. That's much more effective. We'll follow that up with an email, but the email then is almost just confirming what we've discussed, and it's based then on the context of having had that conversation. So how we deliver advice is quite different. And as I said, that's normally we'll try and pick up the phone or have a call with someone to go through a tricky issue.
So it's the communication that becomes just so key, right? Because there's also what's like my experience has been with, I'm not saying just in the legal profession, with any profession that has its own niche, is that the jargon, like for example, the legal jargon, can really confuse the client. They don't know what's going on, and so if you can, like you said, just get on the phone with them for 5 or 10 minutes, that becomes just invaluable. Saves everyone so much time.
It really does. It really does. We do a lot of shareholders agreements, and that's another area that we've changed significantly how we advise on those. Before we do it the traditional way, where someone will come to us, they say they've started a new business with 3 people, let's say, they need a shareholders agreement. We'd go away, write an agreement, send it to them. They get this 30-page agreement. They read some of it. A lot of it doesn't make sense. They're not really sure. There's loads of questions in that document. There's loads of legalese. They kind of get it. They're a bit daunted by it. And they come back with some stuff, some instructions, and try and answer some of the questions, but there's no context. That whole process takes a long time. And often those agreements then will take months and months before you get down to the actual final agreement. The way we do it now, again, is completely different based on experience. And we start that process with a workshop. So we will hold a workshop either in person or nowadays, as I said, we do it on Teams or Zoom, where we go through there's about 14 issues to think about with a shareholders agreement. We'll go through all 14 issues. And for each one of those issues, there's about 3 or 4 typical ways that people deal with them if it's an issue that needs to be dealt with in the agreement. We shine a light on all of that. And once someone understands that issue, they can decide very quickly whether it's relevant to them or not. Because not all of those issues will be relevant to them as a founder group, as a business. But they're making that choice then on an informed basis, having understood that thing. And people bandy about often these things that they hear about in shareholders agreements, like good leaver, bad leaver, compulsory transfers, drag and tag. And often what I find is people have a vague idea of what it means, but they don't actually know what it means. And often they're slightly off key from what it actually does. But we dispel all of that, we explain it, and then they make a real choice. And often they don't need it. But doing it through this workshop first, it takes a big investment of time up front, but you end up with a much quicker process because within a week or two, the agreement can be finalised because people are they're giving you the instructions of what they do and don't want in the agreement there and then, but having understood what it is they're talking about.
Yeah, so they get their own essentially bespoke agreement that's where all the parts are clear, they know what they get as a result of it, and everyone's happy at the end, right?
That's right. And it's so much quicker. I mean, it's not necessarily cheaper, but what you're doing is you're front loading the time taken to come up with that agreement rather than spreading it over a 6-month process where they're getting dribs and drabs of information about what a clause is, what it isn't. You're condensing that into a quite an intense workshop. I can't lie to you. But everyone I've ever done that with always leaves it and says, I feel like I've had like a mini education in corporate law, but now I know what we've got in the agreement, what we don't, and why we don't have the things that we chose not to put in there.
It saves you so much time having to go back and forth by email, saves so much time having to explain something they weren't clear on in the first place. But it does require, obviously, also commitment, I suppose, from the client as well, right? So then, I suppose that they are actually committed to going through that process review as well, as opposed to going like, oh no, I guess we need this legal thing, and then they just leave it to you.
Yes, it doesn't work. It needs that commitment on both sides. And we now don't do shareholders agreements unless a client is prepared to commit to that, because whenever we've done it the other way, it's led to disappointment on the client's part. Like they're not happy with the end outcome. It takes ages. It costs more money than they think. We've got a pretty strict rule now. So we only do it if the client's prepared to invest in that workshop process.
In terms of the necessity when it comes to the shareholder agreement, when would you say is it really paramount that the owners actually have that in place before they consider exiting the business?
Yeah, ideally it's there before you exit, and some time before you exit, and that can be for a variety of reasons. If you have new shareholders joining, if the company is going to need to raise money and issue new shares, it's really important to have clear rules and regulations around how that's all going to work. Ideally, you'd have a shareholders agreement very early on in a business's existence. I understand that's not always possible, but you should do it once you sense that a business that you've started is getting some traction. That's probably the latest point at which you should do it. Because if you wait too late, then it can get harder or impossible even to actually agree some of the more tricky things that you need to agree with your co-founders. It's obviously There's loads of cliches around this where you should fix the roof before when the sun's shining, right? If you try and do it when it's raining, it's a lot more difficult. It's problematic. It's that kind of analogy. So, same with the shareholders agreement. If you try and do it when perhaps there could be more tension or the company's worth a lot of money, the vested interests involved at that point can mean it can distort how fair people are about those agreements.
In terms of what's important for business owners to consider before even thinking about potentially putting the business on the market. So obviously shareholder agreement can be a very important part of that. What do you also see as, well, again, pivotal to and like key aspects that you usually address with most owners when it comes to exiting? What is it that they usually miss?
When a business is just running and they're not thinking of selling the business or taking any investment, they can, to some extent, cut some corners or not have all their legal paperwork in order, okay? And as long as the business is working, that can be fine. Once you have a third party who's thinking about investing in that business, come and have a look at it and ask some questions about, is everything clean and tidy? Do you have contracts in place for all these sort of things? That's normally when these problems are uncovered. So if you're going to expose yourself to a due diligence exercise by a potential buyer or investor, likely it is they're going to find problems because that's the brief. And the problems they find were not problems while you were just operating the business and running it on a day-to-day basis without the thought of trying to sell it. But they are a problem if you're trying to sell the business. And what it can allow a potential buyer to do, of course, is to come in and go, oh, you've got loads of these problems. Your contracts don't have any of these clauses in. This is already bad stuff. We're not going to pay you the price you want for the business. It can just give easy wins to them to give them more strength in those negotiations. So that's often what people do. So before you go through that process, certainly, we suggest to a lot of clients that they should go through some kind of pre-sale due diligence process where you get a firm in to come and ask a load of questions about mirroring what you would go through in a due diligence process. And we always find things that aren't in place, to the extent where everyone will tell us that, oh, my business is absolutely fine. It's a really simple business. It's really well run. We've never had a problem in 15 years. All very good. And then we'll come in and one of the first questions we may ask is, do you have any contracts with your customers? And they'll go, oh, no, we don't have any contracts with customers. Like, oh, well, that's going to be a big problem for a buyer because they're then going to say, well, what guarantee is there that you're still going to get business from these customers, particularly if it's a business that has recurring revenue? It all needs to be contracted with a written contract to make sure that that's definite, because that's what it is you're selling. Pre-sale due diligence. But what I would say is, Boris, that despite trying to recommend that to many clients who we've helped sell their businesses over the last 10, 15 years, not very many people take it up because they think, oh God, how much is that going to cost? Maybe it costs £10,000-20,000. They think that's a lot of money. Maybe we won't spend that. We'll spend that closer to the time when we're about to sell. Of course, what happens is when you are about to sell, that process takes an awful lot of time and energy. There isn't the time then in parallel with the sale process to be fixing all these things. So yeah, you've got to do it as soon as you think, okay, I'm probably open to selling this business. That's when you should do it.
I think timing is really important. And when it comes to timing, most people think about, well, is the market up or down? But timing is also about having all those things in place, making sure that you actually, like you said, you have the leverage as opposed to the buyer, and not preparing in advance. Like you said, it shifts all the leverage to the other side. They have all the power and they can walk away just because of what you thought were minor things as an owner.
And that, they are minor as an owner. They are minor things. But for a third party who may be buying a business and spending millions of pounds on it, quite rightly, they are going to expect things to be pretty much perfect. That's their expectation. But if someone is paying £5 million for a business, that's their right to have that expectation. And you need to make sure as a seller that you can try to give them something which is as near as perfect.
Yeah, so in terms of just talking about, again, what you do at SGM Law and with the clients as well, one of the things that I actually saw, which kind of stood out to me, was what you call crisis control. I don't know if you know what I'm referring to. It's on the website, but
Mm-hmm.
it'd be interesting to just
Mm.
learn a little bit more about it because that kind of obviously jumps out straight away. And so I thought that was quite interesting.
Yeah. So this is an area of work that we do fairly often. The classic one that happens is where there's some kind of fallout or dispute between shareholders in a company. If that situation arises, then you can benefit from having legal advice, but often it's more wider advice that you need, sort of strategic, tactical advice on how to handle that situation. And we're very well versed in helping people navigate those situations. So I've done it for listed companies, also done it for many private businesses. And the sort of things you can do is you can rely on company law, so Companies Act, company law, as well as any legal agreements that you have. And if you look at those two things together, and there's a strategic objective that you're trying to achieve, we can often find ways of managing a situation using those rules and the laws to try to achieve your objective. Or if you could be on the other side of that, sometimes someone is trying to do something to you. Say someone is trying to force you out of a company or remove you as a director to take away your powers. There's things that we can do using those rules and laws to help you minimize the damage caused to that situation. I remember a founder of a prop tech business I did this for some time ago. These are fun, and the reason we call it crisis control is because it feels like a crisis. Say you've started a business, you're a shareholder in that business, you've worked on it for 5 years, blood, sweat, and tears, but suddenly some investor is trying to force you out of the business against your wishes. That is a crisis. You can potentially lose lots of value, and yeah, those things are very fast moving. Yeah, they're very interesting projects because you can add a lot of value for someone as long as you know how to navigate the rules. And oftentimes people aren't as well versed in navigating those rules as they think they are. There's always little ways of manipulating things that we can help people do. Yeah, it's really enjoyable for us because you really have to think hard about how you're applying the laws to that particular scenario, and you definitely need to think very laterally because sometimes you'll take two steps and do something that will feel bad for the situation, but you're doing that deliberately because there's a third step that you know then you can take once you sort of send people down a certain route. So yeah, it's a bit like playing a game of chess and setting traps, and that's how I kind of think about it in my head.
No, that's very interesting because obviously on the other side you have the other legal team potentially, right? That's working with that investor that's trying to again force the owner out. So I think it does become this sort of almost like a fencing match in a way, right? Where everyone is trying to kind of second guess what the other team is going to do. In terms of the disputes as well, I'm just interested to know whether you've come across situations where the disputes would arise as the business they're trying to sell the business. So is that something that's happened? Because obviously, there can be a falling out between the founders as well, right? And then it becomes a lot trickier to sell the business.
Yeah, that does happen. That does happen. We've seen that sometimes. Um, Sometimes these things are simmering below the surface, so there is not a fully fledged dispute, but you can tell that the parties aren't necessarily best of friends. If that's the case, that's okay. I guess as long as it's not causing any negative impact on the overall sale transaction. But sometimes it can stop a transaction. Let's say someone doesn't want to sell, and I've seen this before where a company hasn't had what's called a drag along clause, and a minor shareholder owning less than 10% has been able to say, well, I'm not going to sell my shares in the company unless I get a higher price. So they've almost been able to demand a ransom and extra special terms for them, even though they only own a small percentage. But usually when a buyer is trying to buy a business, they want to buy all of the shares in the company. So that's one situation where definitely they should have had a what's called a drag along clause in place in a shareholders agreement or in their articles of association to avoid this ransom situation taking place.
Makes sense. And I think it's almost that, again, to the point of getting things prepared in advance, you need to make those changes to the agreement before you even consider, hey, like we should probably take the business to the market.
Yeah, these things always come down to preparation, and it's difficult to prepare for a sale because what normally happens is founders of successful businesses will regularly get approached by people who are interested in potentially buying their business. At some point, normally they will say no, they're not interested, or just ignore these calls. At some point that changes, and it's a different point for every single person or business, but at some point it changes, and then they start taking those calls or having those coffees or conversations. And sometimes it's like any major decision in your life. Once you open the door to it mentally, you can very quickly find that from going to like, okay, I'll meet this person for a coffee, to 3 weeks later, suddenly you're negotiating heads of terms for the sale of your business, and it moves very, very fast. When 3 weeks before, you didn't think you were selling your business because, you were just happily going along with it. You thought it's years before you're going to sell or 3 years away. But if someone comes along, you get on well, they talk, the numbers they come up with are more attractive than you thought would be possible at that point in time. Suddenly, you're in a sale process. So it's difficult to prepare. So you almost need to be prepared earlier than you think. It's like doing a will. No one knows when they're going to meet their end. So you should just do a will ASAP. Don't wait until you think you're old and that's when it's more likely that that's going to come in handy. You just do it. It's just one of those things.
Yeah, no, that's right, exactly. And we always say that in exit planning as well, there are black swan events that can happen in anyone's life. There's death, there's divorce, disability, anything can happen to you at any point in time. So it's almost like you're taking insurance out on all these things that could potentially happen and could cause obviously a worse outcome than could otherwise happen. So no, that completely makes sense. I think one of the things that you mentioned about how the buyer can obviously come in and they offer the seller a lot of money upfront, and that can be a very sort of attractive, almost like a hook to get someone in. What I had a question about was, so from the legal standpoint, is there anything that a business owner can do to protect themselves in this process where, for example, someone comes in, makes a very generous offer, they might be under an NDA, but you don't always know what the intentions are behind someone probing, trying to find out more details about the company. So if someone comes in and they want to kind of get to know a little bit more about, hey, can you show me your accounts? Do you have any contracts with the clients? Suddenly, they want to see the client list maybe as well. Is there anything that they can do to mitigate potential risks?
This question comes up quite often, and it is always difficult to answer this. It's all about the context of the person who's approached you and how you feel about what they might do with any information that you give to them. But I would always give people some very simple advice about this, is that you can always give them more information, but you can't, when you give them information, take it back. So better to proceed with caution and just reveal things that you're happy to reveal and for them to keep hold of. And as that conversation progresses, you can reveal more and more. So just take it step by step, because you don't really know. And we have seen this before where someone will approach someone to buy a business, and then only really after the event, those talks fall down, and only afterwards they look back and reflect and go, I think they just wanted to fish around and get some information, see who our clients were, how we did things. And that does happen. It's a very interesting way of gathering intelligence on successful businesses, how they're operating, especially if you're thinking of entering the same market, or quite often you're already in the same market as them. So do it step by step is what I always say. And try to you can rely on an NDA, but if someone's got information, then they've got that information. And if you will need to enforce your rights under an NDA, that's too late. And that's going to cost you lots of money. That's not a great place to be. You don't want to do that. So reveal it step by step.
Common sense is very important in this sense, because a lot of people might even think that, like you said, I signed an NDA, they signed an NDA, happy days, but it doesn't really work like that. So yeah, that makes complete sense. I think when you went through the sale of your business, was there, and I presume that the business, well, actually, let me ask, was the business sold to another law firm?
Yes, it was. Yeah.
So was when you went through that process, was there also like a little bit of like, okay, we're going to do it step by step as opposed to necessarily kind of revealing all the information, or was it more as, hey, like we have prior relationship with this people, with these guys, we know what we can trust them with, we know what we want to maybe hold on to in terms of the information, and then just again take it step by step.
Yeah, I guess you asked, did we follow our own advice?
Yeah.
In terms of how we approached it. I think we did largely, yes, we did, and just revealed things bit by bit. We sold to another sort of a competitor law firm, if you like, although we weren't direct competitors. But we did take that approach and reveal the information as part of diligence, bit by bit, until we became more confident that they were serious, and that the deal was going to be viable. But yeah, they didn't do too much due diligence on us as a business as well. So that was a factor that we weren't having to be so cautious, but we certainly did operate in that way.
And in terms of the process as well, was there anything, like looking back, obviously now there's the hindsight, there's the fact that you work with a lot of business owners who go through the sale process as well. Is there anything that you would have done differently yourself when going through the sale process?
Got more money? Probably not in terms of the sale process that we went through. It was more of a strategic exit at the time, and no, I think that did make sense. Yeah, that did make sense for us at the time. No, it was a good deal. I can't complain at all about it, what we managed to achieve, and it was done quickly and fairly efficiently. So yeah, no, it was okay. There were some sticking points in the negotiations. Luckily, we got those resolved in our favour. So no, it was okay. That all went well, thankfully.
In terms of the timeline, you said that it was a fairly quick deal as well. So how long did it take from the start when you got approached, or you approached the buyers, to the end?
Yeah, start to finish. That was, well, so many of these deals, the start is perhaps earlier than people think. So there was an initial conversation with these people probably 2 years before. As in, there were some initial conversations, decided it wasn't the right time, wasn't the right deal, nothing happened, put on ice. They were then rekindled about 2 years later, and then the time was right for that kind of transaction. So when it was then rekindled, it was on the basis of this prior conversation 2 years earlier. But the actual sort of core process probably took about 3 or 4 months. Again, people are always slightly unrealistic about the timelines for these things. Even us as lawyers, we were. But they always take a little bit longer than you're going to think, because there are practicalities to sort out and lots of different stakeholders and people that need to be consulted about these things. So yeah, that deal I think took about 4 months, which was very quick in the context of what we were trying to do. A typical deal will probably take, from those first conversations to actually concluding a deal, I think some of the quickest we've seen is about 6 months. But that's from the first conversation around, someone sitting down for a coffee and saying, hey, we'd like to buy your business, and going from there. Yeah, about 6 months, I would say. But that's very quick. That is very quick. I don't think people would think it's quick, but that tends to be a very speedy transaction.
Yeah, I think on average, what we've seen as well in the M&A market is like 6 to 12 months is like an average good deal going through, where everyone is actually happy at the end of it as well. What are you finding in terms of the differences? Again, I'm trying to kind of look at it from the more legal side of things, but I suppose when someone is approaching a seller for the first time as an individual buyer versus, for example, private equity firm, or maybe it's an experienced buyer who's had multiple acquisitions, do you find that the process is generally smoother as well because they already know all the boxes that they need to tick?
It normally is smoother if it's someone who has been through the process before, and that is just because they've got the experience and they're a bit more realistic about the timelines. They understand what is needed to actually execute and deliver on that kind of transaction. So it definitely makes it easier. I think oftentimes if someone hasn't done lots of deals, so I've done about 500 transactions. So I am often the person saying to a client that, oh no, maybe this is going to work, but I think it could take a little bit longer. These are the things to think about. That's all based on having done this lots and lots of times. A lot of the people, perhaps who have done one or two deals before, they maybe have only done one or two deals. So their experience is going to be heavily centered on those experiences. If someone's advised on hundreds of transactions, that tends to be a better body of experience to draw conclusions on about what's difficult, what's going to be easy, how long something will take. So yeah, we do tend to rely on that experience that we have.
And I think also in terms of the experience, in terms of someone approaching a business who's an experienced buyer, you know that they would be happy actually to probably take a little bit longer if needed to do the due diligence and to, again, have those conversations, as opposed to someone who's looking to buy the first time, where it's almost like I speak to quite a few buyers weekly, and first-time buyers, they're almost in a rush to get the deal across the line. It's almost like, hey, I have to get this first deal done. But that leads to a lot of problems, of course, afterwards.
Yeah, people are in a rush. And I think sometimes that the problem that can create is when they're in a rush is if they create an expectation that something will happen, say, in 1 month, and if that's completely unrealistic, that can then create the disenchantment and dissatisfaction from the other side. If they think something's going to be very quick and then suddenly, 1 month, 2 months, 3 months goes by and it still hasn't happened, that's where people can start getting a bit frustrated and tense because they were expecting something to take a month. And suddenly now, 3 months later, it still feels like they're far away from the end point. Whereas if they knew from the start that, okay, this process might take 3 to 6 months, I think people will then feel differently about it. And also, it impacts people personally. These are personal decisions for people, and they will have their lives happening, whether they've got family or holidays planned and other things planned. Sometimes if someone thinks something's going to happen in a month, they may cancel their holiday plans. And then if it doesn't happen in a month, and then 2-3 months later, and then it's cancelling other plans and other plans. So that's also what actually happens, is it impacts people's personal choices in life, which can create this negative feedback because of this fake expectation around how quickly you can do these type of transactions.
There was one other point you brought up before, which was the fees they have to pay for the service, right? Which is, to create the shareholder agreement that's correct, or look at it that way. And so when you talk to the clients about sort of how much it might cost them in terms of, like, for example, we need to do this, we need to do the due diligence, how do you approach those conversations? Because obviously, from the standpoint of someone who's looking to sell, the first thing that's on their mind is that, well, I'm actually trying to get cash for my business. Like, I'm trying to get the payday. But here, all of a sudden, it's like, oh, there's an extra cost to it.
Yeah, the cost of any M&A deal is largely based on how complicated that deal is. And what I often see is that in a smaller deal, because there isn't perhaps the ability to pay all of the money for the business on day one, what people can end up with is quite a complicated payment structure for buying a small, a relatively modest business. And that complicated payment structure, what I mean by that is that could be a delayed payment. So maybe people pay people over 1 year, 2 years, 3 years in various installments. And sometimes those payments are also linked to performance of the business, profitability. If you do a deal structure like that, that's very complicated because there are dozens of different ways of manipulating each one of those payments either way. And so obviously you get some lawyers involved in that. One lawyer will add 5 clauses to protect their client in a fair and sensible way. But then those 5 clauses need to have 3 other clauses added by the other lawyer to rebalance that and make it fair for their client. and then the original lawyer needs to add two more clauses. You get the idea. If you have a complicated deal structure like that, that's when the legal process becomes really convoluted. And what I always encourage people to try to do is to make these things a lot simpler. That reduces the cost. It makes the deals much more likely to happen, and it keeps everything a lot easier and simpler. But it does require a leap of faith by both parties to make sure that they're happy to keep it simpler and maybe not complicate the process. Not everyone is prepared to do that because sometimes they think that these things are so important, but that's fine. That's their choice, as long as they do it on an informed basis. That, okay, if you want to have the payment as an earn-out and not just a deferred payment, you may be looking at an additional £10,000-15,000 of legal cost just because of that one choice. But if you think that's that important, if the economics of the deal still makes sense to add that complexity, then fine. So what I always try to do is give people the information to make choices about these things.
What do you see in terms of the legal landscape and how that's changing and perhaps where it's heading over the next, sort of, say, 4 to 5 years? I know it's difficult to predict the future. Things seem to be changing all the time, especially with AI now. But what is it that you think people should be looking out for, especially when it comes to M&A transactions or looking to sell their businesses from the legal standpoint?
M&A is one of those areas of law that doesn't change a lot. So in the years that I've been doing it, over 20 years, not that much has changed. So it remains fairly static in terms of the process. So it's the same documents, some of the points that are taken and what is considered to be market standard. Obviously, these things evolve over time, but really they don't change. They haven't changed dramatically in the period that I've been a lawyer for and doing these deals over the last 20 years. I think that will continue. What is, as you mentioned, AI, that's certainly increasingly having a bigger and bigger impact. And I think that's changing certain parts of the deal process. One big part I think it's already impacting a lot is due diligence and how that is conducted on a deal. And that will continue. That will just get in, people will use AI more and more. I mean, at the moment, what we're seeing some people do, some of our clients, is we will receive an agreement, say, from the lawyers, from the counterparty. Our client will get it. They'll put it into some AI machine, Copilot, Perplexity, ChatGPT, whichever one they use. It will spit out a report to them. They may put a 100-page contract in. But they get then a 20-page analysis of this agreement, and they then will often send that to me and say, "Look, I've put it into ChatGPT. This is what it's come up with. Thought this would help with your review." It doesn't help with our review, because to know whether or not what the computer has said, if that makes sense, if it's correct, you still have to review the 100-page agreement. So it just adds to that process. But at some point, I am sure that, so normally the feedback that these AIs generate at the moment, it doesn't give you clear answers on what you should and shouldn't do. And maybe that's down to the prompting. What are the questions that the AI has been asked to answer? As people get better at that, I'm sure the AI will then be able to generate much more useful feedback for them that can be then applied to the specific document in that deal. But at the moment, it just gives them information, and not necessarily with the context of whether it's important to change, say, a confidentiality clause or some other not that important clause. But that is getting better and better. And, I think we as lawyers have to be employing that ourselves as well to speed up the process. But what tends to happen, I remember my senior partner telling me a story when he was a junior lawyer, so probably in the 70s, because I would say to him, this is pre-computers, so when documents were created on typewriters, And he says that no, the deal process would back then take about the same amount of time, but the documents were much, much shorter. And what would happen then was, let's say a share purchase agreement was 20 pages long. People would be very reluctant to change something because it would necessitate having to retype a document. And so you would only change something if it was very, very important. With word processing and be able to copy and paste and put things, lawyers sadly do just add lots and lots of words and change lots and lots of things in documents that they would probably accept and live with if it was back how it was done in the old days. So yeah, sometimes technological advances such as these can actually make a process more complicated rather than achieving absolute benefits in terms of efficiency.
Yeah, and I think that's a very important point. It's in that we're not quite there yet, where it's replacing the human and replacing the context, like you said, where the context needs to be analyzed and we need to be able to draw conclusions from them ourselves. So I appreciate that, and I really appreciate your time, Rishi. Thank you very much for joining me today.
You're welcome.